So now we're going to move on to your police interview after you were picked up, okay? Now, on Direct yesterday, you said that you and BJ were friends, right?
I knew him, yeah.
Since 5th grade?
Yeah.
And you also told the detective that BJ put a gun to your head that night, correct?
Yes.
And you told so many other stories that the detective asked you if you knew the difference between a truth and a lie.
Yes.
In the first couple of hours of that interview, you kept saying that there was one shooter, true?
Yes, I did.
You said BJ was shooting, correct?
Yes, I did. I said a couple stuff. I was shook up. I was scared. I didn't know what to say. I never been in no situation like that before.
Okay. And then towards the end of the police interview, Detective Hogan told you what he thought happened, right?
Correct.
And then after Detective Casey told you, this is the time for you to sing your ass off, because if not, you're going to find your ass in fucking jail with these fools, right?
Correct.
And that's when you started adopting Detective Hogan's version that there were two shooters.
Yes.
And then that's when you started saying that there was a big gun.
It's never no big guy.
Big gun.
A big gun?
Mm-hmm.
I don't remember.
And that's when you started putting Lil Rod in your story, correct?
Yes.
So let's fast forward to the previous hearing in September of 2021 when you provided testimony, okay?
Mm-hmm.
And that's the first time anybody ever heard about you being trapped on this bottom floor, correct?
No.
Who'd you tell?
I told the police.
You told Detective Hogan?
No, I told the police when they came to get me, where I was, inside the house.
So you told them on the way to the police station that you were trapped in a house?
No, I told my mom over the phone.
You told your mother?
Yes, that's how the police knew where I was.
Okay. And did Detective Hogan bring that up during your interview?
I'm not sure. I don't remember.
So would it refresh your memory to look at your prior testimony from your prior hearing?
Mm-hmm.
Okay. Your Honor, may I approach?
You may. That looks like a pretty big binder. Are you going to point her into something in particular? Okay.
Yes.
All right.
I'm not going to have her flipping around. Yeah.
That's good.
No. Okay. Would you go to page 866? And then to yourself, read lines 6 through 13.
To myself?
To yourself. And when you're done reading, you can just close the book or just look up so I know that you're done.
I looked at it.
Did that refresh your memory?
Yes, it do.
So you never told anybody that you were trapped in that basement?
Yes, I did. I told you I told my mom.
Okay. And yesterday was the first time anybody heard about Bali attacking you, correct?
Correct.
You kept that secret for about, 2019, 20, 21, 22, like 5, 6 years?
Correct.
And you would agree with me that you changed your past testimony several times about who had a gun that night?
No.
Okay. Would it refresh your memory to look at the transcript?
I mean, if you want to put it up, that's cool. I'll look at it and refresh my memory if that's what you want to do.
Okay. So let's start with where you said Lil Rod had a gun. Go to page 809.
Your Honor, I've got some members of the defense side here taking a look. Our understanding, and if it turns out to be wrong, it turns out to be wrong, was that the state was undecided yesterday as to whether they were going to call Mr. Bernard Mitchell. I know at the lunch break, Mr. Hiles was on the stand. His text messages had already been admitted. We went back to speak with him. The state went back and attempted to speak with him. So at that point, my understanding was it was still up in the air. I can be wrong. My understanding was it was still up in the air. Per Your Honor's request, we had discussed as many things ahead of time as possible. The discussions with the state were, and it was very clear for both sides, that we were not going to be objecting and not asking this court to litigate Mr. Mitchell's Instagram records because the state was going to call him. Yes, with them coming in, there were portions that we intended to use with the understanding that that is what would come out in terms of evidence. His messages would come out, so we would want another section in there. If the first section is in there, we would want the second section in there. but he's certainly not our witness. The evidence he presents is not a theory of the case that we would have brought to the table. And so now the state does not want to call him, and I think we're faced with a confrontation clause issue because we relied in good faith on our discussions with the state. We didn't go through and take the court's time to say this is conditionally admitted based on this happening. So we simply relied on what they represented to us. We had the evidence, came in, it was read out. I contacted the state last night to say, hey, I'm not sure what you want to do about this. We feel in a position that we are forced to ask for a mistrial. We really don't want a mistrial. We'd like to be able to rely on what we were told. And like I said, we're checking to see if there was something definitive on the record. But if Mr. Mitchell is not testifying, then we feel we have no option but to ask for a mistrial.
Would the state like to be heard on that?
I guess the state's response, Your Honor, is that the state, after the lunch hour, indicated to
Talking to the mic. Pick one up, maybe.
the state after the lunch hour indicated to the court, as well as counsel, at least for Mr. Ryan, indicating that we were not going to call Mr. Mitchell, basically because he told not only the state but defense counsel that he wasn't going to say anything when he came onto the stand. That was the same thing that was told to us by Mr. Uten. And my recollection is that it wasn't either or is what the understanding was. It was because we were going to maybe call either Mr. Uten or Mr. Mitchell, and yesterday we decided neither. So I don't know how there could be a confrontation issue that's being claimed today. If we decided to put Mr. Uten up yesterday and not Mr. Mitchell, the records would have still come in the same fashion without Mr. Mitchell testifying. More importantly, before any message came in as it related to Mr. Mitchell, the state indicated to defense counsel that we were not calling Mr. Mitchell. We indicated that to the court as well. And
I don't remember y'all indicating anything to the court until the end of the day, y'all. But what I was told by the deputies was that the state had very clearly said they can be transported back. We are not calling either of them, and that was at or right after the lunch hour that I was told that. I asked yesterday morning, is this an either or? And yesterday morning, the state was definitely indicated, you know, it might be one, it might be the other, it might be both. We don't know yet. We still need to talk with everybody. And then we just went on with the trial, and they didn't, you know, after lunch they went back because y'all had made that determination, and you certainly communicated that to the deputies with regard to transport. And you are making the representation that you also let the defense know that. Do y'all disagree that the state let y'all know they didn't intend to call either witness?
At the very end of the day, I had inquired to the court to, you know, discuss what's going to be the order tomorrow, and I said, well, Mr. Mitchell, Mr. Uten, checking, Mr. Kokomo took a look, and before lunch, what was represented to the court said, you know, who are we going to get to, and they said, we may not get to him today. So
That was before lunch.
that was before lunch, and then we came back in, and everything was published.
And everybody I mean, not everybody, but counsel for Mr. Ryan and counsel for the state spoke with, I guess, Uten and Mitchell over the lunch break.
We went back. He didn't want to speak with us. That's fine. We went separately from the state.
Right.
We didn't discuss anything with the state about who would or wouldn't be called at the lunch. And I don't believe before we started in the afternoon. That's not my memory. The announcement before lunch was we may not reach him today. I spoke with him. Obviously, at the end of the day, I still thought they would be called.
my recollection is after lunch, I was sitting there. Ms. Abbasi said, so you're not calling Mitchell? And I said, no, we are not calling Mitchell. That's my recollection before Mr. Howes began testifying after lunch, and we didn't call Mitchell. And the messages came in unobjected or not objected to, and there's been no conditional admittance of evidence that's been permitted or agreed to by any of the parties during the trial of this case, at least the time that I've been here. So it's my indicator, be the state's opinion that any objection to the messages that came in are waived at this point.
Your Honor, our response is we have difference of memory. That's fine. It is what it is. If the state knows they're not going to call him going into it, I don't think it's fundamentally fair for them to publish and then say, ha, you missed it. I don't think that's good faith. As far as, no, we didn't conditionally admit it because we've done everything we can, at least for Mr. Ryan, to avoid taking up the court's time. This is what it was. We all agreed. We all understood. So that's how we proceeded. And now here we are, and we're stuck in a position we don't want to be in.
Well, I'm not quite sure what to do with this. I have a representation from Mr. Abadi that the state communicated to defense counsel that they were not intending to call Mr. Mitchell or Mr. Uten, and that was communicated prior to Mr. Hiles' afternoon testimony in which this evidence came in. And Ms. Abbasi, you're saying, well, it's not my recollection, but I could be wrong. That might be. So
I will not say my memory is perfect. I have no memory of having that conversation after lunch. I'm not going to say, you know, Mr. Abadi's. I can't promise you my memory is 100% accurate, and I'm certainly not getting up and saying that Mr. Abadi's lying. I'm not going to do that. But I have no memory of that conversation at all. And, you know, as I said, I brought up at the end of the day, you know, what's the order of the witnesses? When are Mr. Mitchell and Mr. Uten coming in?
I don't remember that.
I had brought it up when we were asking about witnesses because I didn't know if the sheriff needed to bring them over, and that's what was coming up.
Are you saying that you, on the record, asked when Mitchell and no, you didn't?
That was at the very end of the day. We were just
Amongst counsel?
I believe Your Honor was on the bench when we were discussing just who are we getting to tomorrow.
Yeah, I asked who we were getting to tomorrow. I don't recall you saying, when are we getting to Mitchell and Uten?
Like,
I don't recall the two of them being mentioned at all at the end of the day.
I know I asked the state at that point, oh, you're not calling him? No. And at that point, the evidence had already been admitted.
I'm asking you, did you make that statement on the record?
I don't believe so.
I
We can
don't
check the
either.
record, but I don't think so. I think the last statement on the record was we may not get to them today.
I don't recall that statement on the record or off the record. This is all a surprise to me this morning that now there's some debate about it, because everything I knew post-lunch yesterday, although through the sheriff's office, not through the state or the defense, was that a decision had been made and communicated that neither of them was.
Hello, everyone. It's your girl, Mocha. Can we just shout out day 150, another motion for mistrial? 2 in one day, which is not surprising. It's not like it's never happened before. But you know, we're damn sure starting to set some real records here. You know what I'm saying? Like, really, really is. I don't know if this is the longest running trial in the history of the United States, but I know it's pretty close. I don't know if this trial has had more mistrial motions than any other trial, but gosh, I would assume so. Today, top of the morning, mistrial motion. Miss Abbasi and Mr. Abadi, because they had 2 witnesses that they were were supposed to call yesterday, didn't get to them yesterday, and then at some point said they weren't going to call them, but they had introduced evidence through a DA investigator that's similar to how Sprinkle does his investigations. So that evidence that came in, but those witnesses weren't going to testify to that evidence. That's a confrontation clause. Well, then their way of fixing it was, we can pull them over from the jail again, or from wherever they're at or whatever, which my understanding, it sounded like some form of lockup. I don't know if it was the jail or prison or where, but we'll bring them back because they said they weren't going to tell any of us anything. They were just going to say nothing on the stand, which it seemed like they had nothing in place that forced them to say anything. And it sounded like Lil Rod's attorney, they refused to even talk to her as well. So they was just pretty much like, leave us out of it. We ain't saying nothing to nobody about nothing. So that in itself is a confrontation clause. So they're like, we'll bring him back over here if that's what you want, or at least the one, for him to say that to you. And she's like, whatever. You're not going to grant our mistrial, so it is what it is. It's interesting, even more so to me, that because of how they're doing this RICO, is basically like they're retrying all of the defendants that have a guilty conviction. Little Rod has a guilty conviction. Granted, he's going up for an appeal, but he has a guilty conviction already. But because you're bringing it in as an overact, you really have to literally like re-argue that case before the jury. Next, okay, expected to come and came. Wooni Lee, I think that's how you pronounce his name. He gets on the stand. At some point, he makes a statement about Shannon. She asks if he knows Shannon. He's like, well, not really no more. He's been locked up for 2 years. Everybody's like, defense don't call it mistrial, though. They're just like, okay. They end up, I think, discussing it. And she's like, just listen to my questions and just only answer my question as I'm asking you. Okay. She then puts up some pictures. She puts up a picture of Shannon. SB. Shannon Stillwell. This ain't something that Wooni Lee posted, so why the hell she brought it in through him, I do not know. But this is the way the state decides to try their case. So all you can say is shame on me, because this is how you're doing it. She puts the picture up. What does the picture say? He's reading off the captions. This is the boot kicker. She gives him a copy of the picture. Instead of just letting him read it off of the screen, she gives him a copy on the picture. they at some point had approached about this picture where Westmoreland said, I'm gonna have a problem with that because it has some stuff on there. And instead of redacting it, drawing a black marker through it or whatever, Xing it out where it's not red. I'm sure they had other copies of that same picture. So she didn't need for that one to not mark it out. But she didn't mark it out. She gave it to Uni Lee and she says, what are the hashtags? He's reading all of the hashtags after the caption. And then she says, is there any other hashtags? He reads the other hashtags. And then she says, is there any other hashtags? And she said, it says Free Quay. Any other hashtags? And she's like, you know that thing they always say where you can't get into the mind of whomever, you can't speak towards the intent of someone else? How is it that our judges always seem to be able to speak towards the intent of the state? How is it that our judges always can say, well, I don't think that the DA or the state meant to elicit such and such and such. I don't think the DA or the state meant to get that out on direct. I don't think they meant for their witness to say XYZ. Again, it's just one of those things that the state always seems to sit down with their law enforcement and make sure to tell them what they want them to bring out on the stand, but never what they don't want them to bring out on the stand. And these regular people like you and I that have these plea deals hanging over our head for 20 plus years. Well, I don't have one, but you know, they do. It's so interesting how they always make sure that they don't ever prep their witnesses to not say XYZ. And again, it wouldn't matter if Judge Glanville was still presiding over this case, because this stuff would just be shooting on through. He'd be like, well, I don't think the state meant to elicit that, so we're going to keep it pushing. And, you know, he ain't even going to hear arguments on it because he doesn't like to. He's like, does the state want to say anything else? And the state says yes. And he says, well, I don't think the state meant to get that out. So we're going to keep it pushing. We're at a point now, Judge Whitaker is like, even though I don't think the intent was the intent, I don't think it was meant to happen that way. But how many times can I keep saving you from yourself? Now, with that in mind, my behind been popping all over YouTube to see what I can see, to hear what I can hear. And it seems that Mel from I'm Not a Lawyer But was in the courtroom today. And she was on the Leeds channel. And what she was saying was that the air in the room was thick with, we need to figure this out. Like, you know, she said it seemed as if there was, you know, some that were interested in go ahead and going with the mistrial, and some like that may have been, you know, they have their concerns. So, you know, what's going to be best for my client? You know, is the state going to come with a plea deal of, we're going to offer you 20 years in jail with credit to time served, but you're going to do the other 17? Or are they going to offer them deals where, you know, 5 years and then another 10 on probation, or 5 on probation, or something like that, and credit for time served, so they may do 3 more years? Or are they going to offer them 20-year probation plea deals? You know, because you, as an attorney, I would think you want to get the best deal for your client. It's not about just getting it off the books. It's about, you know, doing what's best for your client. And even a plea deal is a conviction for the state, you know? So, I mean, it could work out. But, you know, in the consensus from everything I've been hearing, the state wants Jeffrey Williams. They want everybody, but they really want Jeffrey Williams. And it kind of makes you think, is it because you really want him to forfeit all of his belongings that you want him so bad? Because the state of Georgia wants all of his assets. Because if he's in jail, in prison, they can have access to all of his assets. He has to forfeit those. That's where it gets like spicy. And Brian Steele is like, not my client. It's not gonna happen. You're not about to, nope, not gonna happen. So, they had got some kind of update, saying that basically the entire defense team was in Fonnie Willis's office. So, and court is at 9, but not guaranteed to start at 9, which means that they may be in the building. They may be in there making, arguments, but it ain't something that they may be televising. You know, like, we may not be able to get the sneak peek. Like, Infamous Sylvia and Mel, if she's in the courtroom, they may be getting the sneak peek, but we won't. Guys, I think this is, I mean, we thought Woody was close. Close. And clearly, Woody Lee, I don't think his intention was ever to do anything rash. Like, he didn't go in there with the intention of let me stir some mess up. I think it was a genuine mistake. But, you know, they also didn't have their curative instruction for the jury to, prior to any of this. And granted, we may come back tomorrow and they say, okay, well, we about to just take this non-jury day and do arguments or whatever and dismiss the whole mistrial notion. They may come back and have plea deals on the table. We'll see what happens. Is that what is it? At Neil BYB? We'll see what happens. I'm on the edge of my seat though, guys. Like, I'm for real. Like, I don't think I can go soundly to sleep tonight because I am so like worried. You know what's weird is I don't feel like just like a viewer. I don't feel like just an onlooker. Like, watching this trial and seeing a lot of the misjustices that have been happening within this trial, it almost feels like my own family member is on trial, even though I know that they're not akin to me. Well, at least I hope. My family's from Alabama, so I don't know. But, you know, it's like, you know, I don't know. It just feels like, you know, you watch it, you kind of come to care about these people, you know, and care about what happens to them, you know. And although I know that it's not the same as their siblings and girlfriends and all that there and the other, it's not. But, you know, I guess it's more than just like, it's not like entertainment for me. This isn't entertainment, you know. Woody was kind of entertainment, but even in itself, Woody has done like interviews where he's like, man, you know, I'm sorry, I didn't realize that what I was doing was going to cause this big of an issue. He's like, well, I know I'm not completely at fault, but I feel like I started some mess. And it kind of seems like the individuals that knew what was going on just kind of fed off of that. Well, like, I'm going to take the blame off me and put it on somebody else. This is the lie that's already being told. Let me just feed off of that. And that's kind of what happened. So, I mean, if these 6 get plea deals, decent plea deals, what's going to happen with the next 6? Are they going to be able to all just take it to trial and pray that something like this happens for them as well? I don't know. But I don't know, it's like heavy on my chest right now. Like, it really is. It's scary. I hope they know that we're all sending prayers and love their way, and we're all hoping for the best. And, you know, I think it's been about more than just a platform for some of us. It's really like been, oh my God, this is happening to people who look like us, who, I mean, not taken away from anything that may or may not have been done, because yes, people were hurt, people lost their lives, but, you know, you don't get a conviction playing dirty. It's not okay. It's not. You, the jail system, the prison system is full of people who were just put in there for conviction. Not necessarily that they did the crime, but they I'm sure are doing the time for it. And other people may be walking free. You know? Imagine Prison Break, that TV series, in real life. You know what I mean? Like, real life, somebody being convicted of a crime, a heinous crime, and knowing it wasn't them, but not having the ability, the finances, the belief of other people besides one family member to try to change what was done to you, and you have everything working against you. You know, the government has endless finances that they can get to convict you, but you only got so much. You only got so much, and regardless of how you working for every little bit you got. And some of these people are depleting their bank accounts. Their families are depleting their bank accounts. So they may not have the funds to do this all again. You know? So that's my it for today, guys. I hope it works out. Bonus note, Steele won. The Supreme Court dismissed his contempt without even hearing arguments on that. Gone. In addition to that, Ashley Merchant pretty much won her lawsuit against the Fulton County DA's office. Ain't that speaking to something? Yeah. But we'll see what happens tomorrow or Friday. We'll be tuning in. Like, share, subscribe. Thank you guys for tuning in. I appreciate you. I will be adding some clips from yesterday because I didn't do a rant yesterday because I had a migraine and my rant was going to be ugly. So I'll include some clips from yesterday with Miss D. Williams crossing Mariah. Yeah, we'll get that in and out. I'm not going to lie to you. I do not like a body when he does the reg. It's a snooze fest. So yeah, but I'll put Miss D. Williams cross in there for you guys to see, and some clips for today. Like, share, subscribe. Thank you for tuning in. Live stream coming this Saturday. Regardless of what happened, we'll recap the week one way or another. Thank you guys so much for tuning in. Peace and love. Bye, guys. Thank you.
Is in 37 NN.
OG Boo. OG Boo.
And who is that?
Shannon.
All right. And can you read for the jury the caption?
Read his caption.
Yes.
It said, ain't nothing more compatible than a trench. A carbon while in the trenches.
And then is there a hashtag?
Hashtag no slime left behind. Hashtag 2Bs. Life size.
Okay. And is there another hashtag?
Free Quay.
Is there another hashtag on the screen?
Oh no.
Your Honor.
It's in this paper
Your
right here.
Honor.
You got me reading.
Your Honor, I have to make a motion.
All right, I'm going to excuse
I wasn't looking at the screen. I was looking at this paper.
That's fine, don't worry about it. Can I ask you to step outside for just a minute? And jury, I'll excuse y'all for just a minute. Mr. Lee, can you step outside for a minute for me, please? Thank you.
Your Honor, we're making a motion for mistrial on behalf of Mr. Nichols. We're not going to be able to unring this bell. Your Honor, this is the exact same issue that while we were at the bench, I brought it up. It was Exhibit 37NN, that the hashtag, there was a hashtag on that exhibit that said Free Quay, which would definitely indicate to the jury that Quay, has spent time in jail or in prison The state agreed. We stipulated that they would redact it. And then the state presented, I guess, to the witness the unredacted version, didn't prep him to not comment on it, and he did. And, Your Honor, before we had the opportunity for you to preside over us, this happened already again. And I made a motion for a mistrial. Now it's happened again. So now the jury has repeatedly heard about Mr. Nichols being in jail, being in prison, and you cannot unring that bell. We would ask for a mistrial.
Your Honor, Carter Matthews for Mr. Marquavius Huey. We join in that motion for mistrial. And what's important for this court to know is that 45 minutes ago, there had been a reference to a person being in jail. Now, this witness has identified Marquavius Huey and has also identified Marquavius Nichols. So all the state had to do was ask this honorable court for an opportunity to have this witness maybe step out of the courtroom and go over with that witness that, we don't need to say anything about someone in jail, what have you. That did not happen before he went on the stand, nor after that first slip up by this witness. There may have even been a document right there on the witness stand that should have been pulled from the state of Georgia from that witness stand so that this could have been avoided. So, Your Honor, we are joining in that motion as well.
Oh, hang on. It's all right. You just didn't know, but we'll let you know when to come back in, okay?
So we join in that motion, Your Honor.
Your Honor, and I just want to briefly add that it is painfully obvious that the state is not prepping their witnesses. You can tell by the way when the witness spoke the first time and he said, oops, am I not supposed to say that? Like, oh, I had no idea, which makes it obvious that the state had not spoke to him, had not prepped them, and this has happened repeatedly. It's happening over and over again, Your Honor, and we're just not going to be able to unring 100 bells.
And finally, Your Honor, Mr. Marquavius Huey, it's been established that that his nickname is Quay.
Okay, isn't there going to be, we talked today about, isn't there going to be a stipulation that references to Quay, at least at some points, are not either Mr. Nichols or Mr. Huey? We did.
Yes, Your Honor, and that's a few things. So one, Your Honor, it was not intentional because we clearly...
Okay, but it was sloppy because I presume he's reading from the document that you handed him instead of reading from the screen.
And we should have instructed him to read from the screen, but...
Or you should have presented him with a document that had that part redacted. It's just sloppy.
The issue came while he was on the stand, Your Honor. So the issue did not come prior to. Ms. Westmoreland walked up to me while he was on the stand and said, I'm going to have an issue with that. Can you redact it? That is when the state became aware.
Then it should have occurred to you, you know what, I'm handing him a hard copy of this document that is unredacted.
But not if there's multiple Quays, Your Honor. If I don't know which Quay that...
Hang on. Can we stop having people come in and out when I've asked the witness to step out and every time the door opens they can hear what we're talking about? Please, just for a few seconds. I'm not asking anybody who's in here to leave. Huh?
The state is in charge of the witness, and they're supposed to be guiding the witness to the room.
And so that is the point in which we learned of it is we redacted it on here. Ms. Westmoreland brought it up here.
Yeah,
when
and you didn't read it. So the jury
said,
didn't see it, but now the jury has heard it. I don't think it is really that, much of a crisis because there is going to be this stipulation that Quay is not always either of these defendants. So, nor is it obvious to everybody that free whomever is such a quote about who knows, everything these days. And so it doesn't necessarily indicate that whomever Quay is, Quay spent time in jail or in custody or in prison or anything. They say it about, Hollywood stars who are in a breakup. It's not so obviously, oh, this must mean this person was in prison. But also, we were already saying Quay isn't either of these people. So let's just, whether this was one of these people or I don't even know who it did refer to.
And we don't know because it's not his post. He was reading someone else's post. So it could be a multitude of Quays.
You talked to his attorney earlier, right?
Yes.
And did you get any kind of an indication? I don't know if this was one of the things you were going to, but it's an issue now. And you said before lunch that you were going to ask Mr. Rubin.
Yes, we did ask.
Do you know at this point whether the free Quay referenced, this wasn't even his post, was it?
It wasn't. And it wasn't an issue until so when I talked to Mr. Rubin at lunchtime, this wasn't something I was going to address with him because it wasn't I did not realize it was an issue. Mr. Rubin found out for me that Slack Quay is not either of these two Quays.
Okay, but this isn't Slack Quay. This is just Quay.
Right.
I know. So why doesn't everybody, they don't know how it's spelled. They only heard it. Why doesn't everybody just enter into some sort of a stipulation that the free Quay or the reference to Quay just now isn't either of these people?
I don't know if it is. So it was.
Whether it, okay, so.
Your Honor, the state can enter stipulation that we weren't referencing, and we as a state of Georgia.
Okay, that is not a reference to, if you would prefer that.
So you want to buy a house using your VA benefit, but you have no idea where to start. Well, here's the good news. I'm Jennifer B.
They won't have wasted, 10, 12 months of their lives in this trial.
Yeah, we can come over to it.
Okay, do it now.
A few weeks ago, but as far as 36 NN, 37 NN, and 47NN, those are the issues that I brought up on behalf of Mr. Stillwell. Those involve Mr. Stillwell, and I brought them up yesterday morning.
Okay.
But as far as anyone else is concerned, these are not things that have been litigated, except the ones that I brought up yesterday.
Okay. So, does anybody else have any objection to any of these items?
Your Honor, I was proceeding on the state's email, which was sent two days ago. This is what we need to review for Rooney Lee, so I've not had a chance to go through all of these.
Y'all are just too much, honestly, all of you, or most of you, not all of you, but a lot of you.
Your Honor, to be clear, so when we made the witness boxes from 1 through 30, 31 through 60, and 61 through 100, for the, there may be a photo here that, you forgot to put into this witnesses folder, but all from discovery. So when we're creating these, like the exhibit PowerPoint, some of it includes exhibits that are already admitted in the trial itself. It's literally the PowerPoint in order of how the state's going to ask direct questions of this witness. So there shouldn't be any surprises with what's in this PowerPoint in terms of, I don't know what day or week it was that we went through, but I know that there was a moment where we got through all of them, where the court would say, does anyone have any objections with this witness? Does anyone have any objections with Mr. Sprinkle, with Agent Burney? And we went through number by number, and of course, if an objection is raised, this honorable court will hear it from any party. But, when we say we haven't litigated or have litigated, in the state's minds, when these issues are brought up, does anyone have an objection on the floor for this witness and the exhibits the state has indicated that they may use with that witness? If there's no response.
All right, well, take the lunch break and look and see if you have objection, and can come back at 1:15. Yes.
And I can speak to one, just so everyone knows. I know I have an objection now. I didn't realize it was in this PowerPoint, but it was something that was recently, the state recently indicated that they plan to use, which is number 12. That's a screenshot.
I don't know what you mean by number 12.
Number 12 on the PowerPoint. It's
46.
Slide 12.
Okay.
46
NN.
And that's just a screenshot. I believe that to be a screenshot of the beginning of a 15-minute video. And I believe that video is titled something like A Night with YSL and 4L. I've watched that video. I've reviewed the video. It's basically a group of young men at a music studio and in the parking lot outside the music studio, and they're kind of interviewing each other, and I guess it was released as a promotional type thing. But I don't know why that 15-minute video would be relevant or admissible.
I can email over the different timestamps that are the most relevant portions of this video. It's not the entirety of the 15 minutes, and I'll do that before I leave court.
So are you saying you are only planning to play
certain portions of the video?
certain little distinct parts of it?
Yes, and I'll send that over right now.
Okay, do that right now, and then when we come back at 1:10, now we can take it up. No, I'm not. No. All right, so anything else we're gonna need to deal with? Oh, so the limiting instruction, if nobody has anything else to add, does anybody have anything else to add on that limiting instruction that I'll read before Mr. Ryan's conviction is entered?
Well, I don't know as to whether we made a number 1 or number 2 decision.
Yeah, I decided it on my own because nobody got back to me. I picked number 1.
That probably would have been my pick, but I just
All right,
I want to reiterate, though, that I agree with Mr. Steele's position that ultimately neither one of them eliminate the confusion from, boy, we can use some of this against some of the people, but we can't use some of this against some of the people. So I want to reiterate that and just reinforce that as well.
All right, so I have, at this point, I mean, I can send it back out, but let me just do that real fast. And I haven't changed anything with regard to, let's at this point just focus on the Mr. Ryan one. Let me get that over to Ms. Pursfield so she can get it over to y'all. But I've taken out the reference to overt acts numbers or overt acts at all. Because when I started trying to craft something that would explain, hey, this is to overt acts, but that's not all you have to, you know, find if you're going to find, when you're making your determination on count one, I realized that it is not really just to overt acts anyway, that it could be taken into consideration in their determination of whether they think anybody was conspiring to engage in a pattern of racketeering activity. And that just goes down a whole, I don't know, wormhole, black hole, I don't know what, of having to stop and give the final jury instructions now, which I'm not going to do. So I'm just saying, count one. Yes,
Your
sir.
Honor, on behalf of Mr. Stillwell, we appreciate the court's efforts, and this is a difficult situation, and we are just, for the record, joining with the thoughts of Mr. Steele and with Mr. Harvey that a jury instruction is not going to be not enough. But I just wanted to place that on the record.
I mean, I assume everybody's joining in that objection, and that's fine. I've looked at a lot of different federal circuit case law involving RICO cases, and it appears that even when a conviction of a co-conspirator comes in, as long as a limiting instruction is given, there's not a confrontation clause problem.
And I just feel the need to bring this up at some point sooner rather than later. There are convictions of Mr. Jimmy Winfrey, my client, Mr. Stillwell, and I believe Mr. Nichols that have come into evidence.
Right.
We brought up these issues previously with the prior judge, and we were not given. We asked for them not to come in. We asked for limiting instruction, and we were not granted those things. So I don't know how we're going to cure that for those.
So I mean, I thought that we had discussed the Winfrey one, and I said I would just at the end, when I remind them of all of the things that are only for certain purposes, do that. I didn't know that anything of Mr. Stillwell's had already come in without a limiter.
They have, and I believe Mr. Nichols as well.
Okay. All right. Well, then I will add those two to the limiter I'll get at the end. And again, they're not supposed to be deliberating until the end anyway.
Okay, so when you're saying at the end, you're talking about jury instructions.
My jury instructions, yes. All right. See y'all in a fairly short amount of time. What have y'all come up with?
All right, wait, hold on, Matthews. Before you say we have a stipulation, F, Judge, once you rule on our mistrial, on my motion for a mistrial.
Okay, so are you asking, what kind of a mistrial are you asking for?
Your Honor, I believe that we were goaded into the mistrial.
Okay, well, I do not believe that, because if you had seen Ms. Hilton's face when that came out of the witness's mouth, she was appalled, and I do not believe that they are purposefully trying to insert error into this trial to make y'all ask for a mistrial so that they can try this case again. I think it is continued, and I am sorry. Y'all have, this gigantic, ginormous universe of evidence that maybe if you narrowed down, you would not be making these kinds of mistakes. But I believe that to be a mistake.
Your Honor,
So I'm going to deny a motion for a mistrial with prejudice. That one, I don't believe that the facts bear out. Would you like a mistrial without prejudice?
yes.
You would? Who else would? That means, of course, that the state would be free to try every one of y'all again.
Just a moment.
Sure.